What are the options now left to Kojo Ponkrumah and by extension those interested within the NPP fraternity?
Yeah, certainly. Appeal or review is as of right, and certainly once they have applied for the full ruling of the court, to be able to study and to apply themselves with the grounds upon which the court made such a determination. That is the right of the client, and he has instructed his solicitors, Senior Frank Davids. They have applied for the full ruling of the court to be able to study it and make a forward determination as to whether or not they are going to appeal the decision by way of a review or whatsoever. But this is a way that we must look at it clearly. I don't understand why, at the extent, as members of the reading community, it is inclined to say, like I mentioned earlier in my opening remarks, that we are officers of the court, and we are addressed as such as officers of the court. And even the labor provisions give, by way of leave and those, every year, you are entitled to your annual leave, which even if you discount, certainly you'll be forced to go on leave because the law mandate is a statutory provision. Right. And once a statute provides, why are lawyers being discriminated against that we can go on leave? Well, right from January to December, it's a full working day.
In the ruling, the justice talks about context for discrimination, if I'm getting him right, because he seems to say that what the is it 17 and 23 seem to be saying is that there's context for discrimination. So in other words, if it's not about race, if it's not about gender, if it's not about the specifics mentioned within the said article, then you might be taking the word discrimination out of context.
Is it? When you read Article 125 of the Constitution, it clearly states that justice emanates from the people. And the people of Ghana, the sovereign people of Ghana, are at best described as the justice because the power emanates from us, and we have entrusted same into the judiciary to administer on our behalf. And once they are doing that on our behalf, you see, in statutory interpretation, you are required to read the whole document as a whole. So if you pick 17 and pick other ones and leave others, then it means that you are leading to the province of absurdity.
Now, which one was left out for you? Because Kojo came with 17, 22, and 293. I guess. Yes,
that was his grounding.
So so that was the grounding. So is that not the context within which he's trying to look at this?
That was the foundation, right? And this is a constitutional court. This is a constitutional court. Right. Once it's a constitutional court, they are not restrained by giving a decision that will stand the test of time. You see, we in court or in law, we mostly refer to decisions of legal luminaries like Lord Denning, Lord Diplock, and a whole lot of people, Viscount Sankey, and those things. And their decisions have stand the test of time, because they made succinct decisions that have stand the test of time. Succinct decisions. And if we keep referring to decisions in 1800s, in our current generation, then it means that those judges were clairvoyant. They were able to read into the future, made decisions that affect the lives of the current generation. Why can't our judiciary, why can't our apex court make such determinations? Because we say... Are
you not inviting them to go beyond what's before them?
They are not stopped from going beyond what is before them. You see, we have currently departed from the purposive interpretation to statutory interpretation, constitutional interpretation, to modern purposive approach. That clearly distinguishes constitutional interpretation or the Constitution as a living organism, that the Constitution is capable of growth. So if black and white states that A, B, and C, what are the current trends that interpretation should give life to the meaning of the Constitution? To ascribe certain meaning to the Constitution that will help shape societal norms and the likes. You see, if you're asking us to go on leave, I am a worker. And as a laborer, I am entitled to my annual leave. So if I decide to abandon, if lawyers decide to abandon their clients in court, then it means that we are denying clients of what? Fair legal representation. Do you get it? What becomes of, say, Abdul Hanan Alubida in court? Or say Edubuahin in court without a lawyer, in these high-profile cases with enormous interest. What's
making it high profile for you?
Yeah, because of the interest of the state. Because of the strong interest of the state. How many criminal trials in this republic is directly being prosecuted by the landed attorney general? Because Article 88 grants prosecutorial powers to the attorney general. When you go to the district court, the circuit courts, it is the police prosecutors prosecuting. Even in the high courts, there are other matters running in the high courts, narcotics cases and other cases, murder cases, which are felony.
Yes, but which are serious, grave in nature.
In terms of its nature. But the Attorney General has decided to pursue Abdul Hanan Alubida, has decided to pursue Bernard Mchibo-Siako alias Untimi, has decided to pursue Duboahen, has decided to and this case are being directly prosecuted by the Attorney General. So that should be a problem with the AG and not the courts, is it? We don't have a problem with the AG.
So why are you not having a problem with the AG?
We don't have a problem with the AG. It is, you see,
seeking to say
the shrine of justice.
CJ that has a problem.
The shrine of justice. The CJ is the guardian of the shrine of justice. And if he decides to shut the door of the shrine of justice against well-meaning, well-intended citizens whose rights must be protected, then we should not have that shrine.
In whose interest should the CJ deliver justice? You just said the people of Ghana, isn't it?
The people of Ghana.
Are the people of Ghana interested in matters relating to Galamsey?
That is why you should ask yourself. You
no, but I have to ask you because you have to establish that. No, I know, but no, you are Ghanaian. No, you are Ghanaian. Don't choose to be.
And I see your audience smiling when you mention the issue of Galamsey. I can see your audience smiling.
Yes, I know. Don't choose to be a
the existential threat.
You are a citizen too.
Yes, the existential threat.
Yes.
Shaking the foundation of this beautiful republic called Ghana currently.
Yes.
Is Galamsey. Currently, our waters are gone. Our forests are gone.
Yes.
Our lands are gone. Everything of ours is going.
Right.
We have fine laws to protect it. And one beautiful thing is that governments upon governments have elevated this Galamsey issue into a securitized subject. You are international relations professional. And when you hear of securitization, you know that when government elevates a certain political issue to the level of national security and approach it differently, looking at NIMOTs and other stuff, that means that government is injecting capital to fight it. Are we fighting it as we ought to fight?
But the securitization started even from your administration.
Absolutely. But we achieved a certain result.
Should a CJ who happens to be a public officer, that's how the judgment describes him.
Yes.
In whose interest should he be working? In the interest of the state or in the interest of your clients who you have private relations with?
So this is where Article 296 of the Constitution clearly triggers in. And that is a sacred injunction on the exercise of discretionary powers. That discretionary powers should not be exercised in an arbitrary or capricious manner. Discretionary powers. We are complaining about water, the degrading of our forest reserves, degrading of our farmland as a result of Galamsey. How many of these Galamsey cases are being prosecuted in a manner as we are seeing today in respect of former political appointees?
At least one has gone through.
No,
at least one has gone through. This case has gone through.
It's an impugned judgment. It's an impugned decision. If you read the judgment, yes, I was part of the lawyers that prosecuted that matter, and I can tell you that decision is a dangerous precedent that we have set for this.
Because it's impugned.
It's impugned.
Circumstantial evidence would not matter, is it?
What is circumstantial?
But that's what
what is circumstantial?
But that's what the judge relied on.
Absolutely. So that's why I say it's an impugned. Which, with respect to my lady Odriko Kuviti, I'm not here to.
No, I get that. Yeah.
But with celestial respect to her, she had it wrong.
You feel that the mathematical equation didn't?
No, she had it. She had it absolutely wrong. In as much as we respect the decision of a judicial body, properly constituted.
You still feel there's a problem?
She had it wrong.
Okay, that's aside the point.
And you brought in the issue of circumstantial evidence. This is a case where the person who was arrested, engaging in direct action of illegal mining, came to court and said that yes, I was instructed to reclaim. I was instructed to plant coconuts, of which I've planted 18,000 seedlings.
Yes, but we're just not really litigate that matter. I'll just bring it. Yes, okay.
No, I'm just saying this in passing that I have done this.
Yes.
But I also mined. Did you share the process of the mining with the person who asked you, who gave you the legal entry onto the land? He said no. Who owns the equipment that were seized on the land? I own them. Whose workers were on the land? These are Kunta mining workers. Said no, they are my workers. Shared proceeds? No. benefit, no, whatsoever. And I'm asking you, Blessed, you are a Ghanaian, and you know this shared tenancy, Abunu Abusa, that when you give your land to somebody to cultivate, in Abunu or Abusa, do you give the person money to go and farm? I don't know what you say. No. If you give your land to cocoa farmer, that yes, I have 10 acres, use it to cultivate cocoa. I don't know if it's Abunu, that's shared tenancy. You divide into two, then you choose one half. If it's Abusa, you divide into three. Are you getting?
If you give your room to someone to stay, to live in, will you go and check the place or not?
No, we are not coming in there.
Okay.
Where you are coming?
That's why I don't want us to really get the matter. Let me just, there is
nowhere that the decision of the court and the impugned judgment of Benedict Chibosi Akontamai was grounded on whether or not the person went to the site to inspect whatever activity that was ongoing or not. But the decision is that yes, the court chose. You see, there has been a time-aged principle of law that when there is no direct evidence and when there is no corroboration with regards to accomplished testimony, you are here, the AG says that the guy entered into plea bargain with agreement.
I don't want us to really...
No, I'm coming. Once you brought the issue of Galamsey, that is where we need to expose
what's happening,
the double standards of government in this matter. Once you bring an accomplished testimony, the court has stated that they should treat the testimony of accomplished persons with caution because it must be corroborated. Who corroborated the testimony of Inkum?
But won't be Wouldn't be himself did, is it?
The testimony of Henry Okum, who
wouldn't be himself did, isn't it?
So it means that you needed a testimony of the accused person before you can make your case. That is why we say that the case that has even been terminated at the time that we filed the submission of no case to answer.
Okay,
that is the prosecution's case.
Answer this question for me.
So this is the injustice.
No, I get it.
That has been done to Benedict Chibosi.
Okay, we'll wait for
an innocent person languishing in jail.
Okay, we'll wait for the appeal process that you're carrying out. I want you to answer this question so that I can bring in Dr. Isaka and then come back to Ivan. And the judge is asking a question about I was going to ask you about the discrimination, right?
Yes.
What specific discrimination happened? Like what specific discrimination happened or is happening in this? Because there's no specifics as well.
Get it right that when the law is right on the enforcement of fundamental human rights of persons, and this is a public interest matter, it is not a personal matter that affords Kojo Oponkroma to discharge the burden of bringing out to the court the issue of direct infringement on a person's fundamental human right. To say that, you have been discriminated against me because I am an Ewe, or because I am an Ashanti, or because I am a Northerner, or because I am that. He went to court strictly that based on the time-aged principle of legal vacations, where the courts are enjoined to take interim proceedings with regards to bail applications, interlocutory applications that needs to be settled because of the long vacation of 2 months. There should be somebody, a guardian of the law, to be around to be able to manage these circumstances. You don't go into full trials with illegal vacations. They should tell us how many of these cases, in matters that they are quoting, it is clear from records of proceedings, I will share some with you, that even it was the lawyers that agreed that, because you have reached a stage of cross-examination, you needed just 2 days. Then let's fix some 2 days within August so that you can complete. Then we can terminate and come and continue within the new term or the new legal year. Because in law, our new term or the new year, our new year begins from 1st October. That's why we hold our sacred New Year service to usher in the new year and be able to start the production. So even as far as the new year or the new term is concerned, it mostly starts within the second week in October.
All right.
So it is a result of this. So if you select that, specialized courts must sit, and because we need to get this case done by December, you have set KPIs for yourself. Edu Buahen, Abdul Hanan Alubida, and others. That is why we say you are discriminating against them.
Right.
Then tell us that yes, because of the exigencies of time, we are not going on vacation, and all courts must sit. And we know that you are exercising your administrative authority. Your sacred discretion, not in arbitrary or capricious manner, but in accordance with the dictates
I'll come back to you because there are a lot more questions. In fact, the judge talks about how these are all criminal matters. So maybe we'll address that next, because he spoke about that in the judgment too. That legal vacation is in respect of civil matters. So probably you might want to note that down so that you address that for me as well.
I'm happy that you are distinguishing it now.
Okay.